Let's start with the revision of the SEBI Act, Unit 1, SEBI Act revision. First of all, what were the main objectives of the Act? The main objectives of the Act, the main objectives of the SEBI Act, the main objectives of the SEBI Act were three most important objectives. That is to protect the interests of the investors, to promote the development of the securities market, and to regulate the securities market. These were the most three important objects or objective of the SEBI Act. And apart from this, we have some more objects like to prohibit insider trading, to promote good and fair dealings in the securities market, to monitor the activities of all the people connected with the securities market like the stock exchange, mutual funds, collective investment scheme, merchant bankers, etc. Right? So the main three objectives of the Act was to protect the interest of the investors, to promote the development of the securities market, and to regulate the securities market. Next, now we are going to study about the establishment and the incorporation of the SEBI. We are going to study about their structure, about the members, about their age, about their removal, about their resignation, all these things that now we are going to study here. In case of establishment and incorporation of SEBI, first of all, SEBI is established as a, everyone try to recollect along with me. SEBI is established as a body corporate, and therefore it has a perpetual succession and a common seal. It can own property, it can hold property in its own name, it can purchase, sell the property in its own name, it can sue any other person, or it can be sued by any other person. This is the main feature, this is the main characteristic of your SEBI. Now, in case of SEBI, in the composition of the SEBI, in the top management of SEBI, we have four categories of persons. The way in which we had remembered this was 1, 2, 1, 5. Right, 1, 2, 1, 5 was the way in which we had remembered. First, 1 stands for a chairperson who is going to be appointed by the central government. Two members from the officials of the central government who will be nominated by the central government. Then one RBI official, one member from the RBI official who is nominated by the RBI. And then we are going to have 5 other members. We are going to have 5 other members, out of whom 3 of them should be whole-time members. Right, this was the composition. This was the most important composition of your SEBI board. Now, in that, the next thing that we have is the tenure. Okay, the chairperson and the whole-time members, chairperson and the whatever number of whole-time members we have there, chairperson and the whole-time members will be holding their office for a period of 5 years, will hold the office for a term of 5 years, but maximum up to 65 years of age. And once their 5-year terms get over, after that they can be reappointed again. There is no restriction in that. Similarly, for the same person, they should be such people who do not have any interest, who do not have any financial interest, who do not have any other type of interest which can affect their independence. Right? They should not have any such interest in the SEBI. Then all the people who are sitting in the management, of the SEBI, they should be a person of ability, integrity, standing, knowledge, and having experience in the field of ELAFA, law, accounts, finance, administration, economics, etc. Right? These were the pointers that we had studied there. Then after that, we studied 2 things. One was about the resignation, other thing was about the removal. Okay, CG, central government had appointed all these people. So now central government has the right to terminate the services. It has the right to terminate the services of the chairperson and those 5 members, the last 5 members, before expiry of the tenure. Means they can be removed either immediately by paying 3 months salary and allowances, or they can be removed after a period of 3 months by giving the notice today itself. This was talking about the removal. Okay, and the other members, any other person, if they want, they can resign, they can relinquish their office by giving a notice to the central government of 3 months in writing. Right. Now, the reasons for removal. What were the most common 4 reasons for removal? The central government can remove any particular person if that person is adjudged as an insolvent, if that person is declared to be of unsound mind, if that person has been convicted of any offense involving moral turpitude, or if that particular person has made wrong use of his position, or we can say he's abused his position, which is causing in harm to the public interest as per the central government. Then in that case, these people of the SEBI can be removed, but obviously only after giving a reasonable opportunity of being heard. Right. The next thing, next pointers, next section was a one-time read section, meetings of the board. That SEBI, whenever it wants to, discuss anything with its members, SEBI, whenever wants to conduct any particular meeting, it can call for the meetings. There is no problem. But however, we do not have those provisions, because the meetings will be conducted as per those rules, as per those regulations, which is specified in the regulations separately. But the important thing here was SEBI can also call for a meeting, right? Acha, another thing, after that, if suppose there is any particular person, okay, if there is any particular person who is an interested director, okay, any person who is a member of a particular company and who is also going to attend the meeting of the SEBI, if that particular person has an interest in the matter which is going to be discussed in the meeting, if he is interested in the matter which is going to be discussed in the meeting, then he will have to disclose this particular fact and he shall not take part in that meeting. Right? He shall not take part in that particular meeting for that matter. In that particular matter, he should not have any involvement. Otherwise, again, it is going to affect the decision which is taken in the SEBI meeting. Then similarly, next section number 8, which says that, say for example, if there is any defect, if there is any vacancy, if there is any defect in the members of the SEBI, if some person's place is vacant, or if some person is not appointed properly, or if some person is not having the requisite qualification, then they say that no problem, the rest of the members can take the decision and that decision will be valid. Okay, that decision will be valid. It is not going to invalidate any proceeding. It is not going to invalidate any decisions which have been taken by the board. Right. Now, after that, the next answer which is coming up here is section number 11. Important answer. Section number 11, few points were important as there were some amendments here. Section number 11 talks about the powers and functions of the SEBI. In this totally we had 5 points. First point was very, very simple. First point was talking about the duty of the board, in which we had to write the 3 main objects of the act, that is protecting the interest of the investors. I'm just repeating so that it gets fit in your mind. Okay. First one was to protect the interest of the investors, then to promote the development of the securities market, and then to regulate the securities market. Right? This was the first point. Second point was some specific powers of the SEBI, like to regulate the business of the stock exchange, to regulate the business of the other intermediaries like merchant bankers, collective investment schemes, etc., to prohibit insider trading, to prohibit the fraudulent and unfair trade practices which are happening, to promote investors' education, to call for information from any particular person, etc. These were some specific powers. Of the SEBI. Third point was crucial, which said that SEBI also has the power to get the inspection done. It can carry out the inspection of any books, accounts, documents, papers, etc. But it can do the inspection. In case of a listed company, proposed to be listed company, only in that case when it is of the opinion that the company is involved in insider trading or fraudulent and unfair trade practices, right? In case of all other companies, in case of all the other entities, it can do the inspection. It can do the inspection of the RAC, it can do the inspection of the merchant bankers, of the brokers, etc. Everything is allowed. But in case of a listed company or proposed to be listed company, it can be done only if it is a serious thing. That is, if the company is involved in insider trading or fraudulent and unfair trade practices. The fourth point is a repetitive point, that SEBI has all the powers. SEBI has all those powers which is vested in a civil code, right? SEBI has all those powers which is vested in a civil code. All those things which we have been studying right from our PMLA, all those things are there. Another thing, next point was a important point because we had certain amendments here. Now here basically SEBI can exercise certain powers during investigation. We are going to study investigation in section number 11C. But during investigation, if SEBI thinks that something is not good, something is not proper, then it can take certain steps. Or even after the investigation is done, after that also the SEBI can take certain steps. Either it can suspend the trading in the recognized stock exchange. It can stop some people from accessing the securities market. It can suspend any office bearers of the stock market. It can discharge any proceeds or the securities, means it can seize anything. it can attach the bank accounts, it can attach the property which is involved with this particular violation which associates with the securities market. The important point and the amended point here was this can be done for a maximum, by default it can be done for a maximum period of 90 days, but after attachment we have to go and intimate about this fact to the special court, and if special court gives us a confirmation, then the attachment can continue till the end of the proceedings, till the proceedings get completed. Till that time the attachment is going to continue, and if later on if we are finally held guilty, then the recovery proceedings is going to start against us. Okay, recovery provisions also we are going to study here, means by selling of our movable property, immovable property, attaching the bank account, detaining any person in prison, and appointing any person as receiver to manage the properties. Okay, this again we are going to study in a particular section, and we can receive SEBI can basically give directions to any person that you cannot sell off. Okay, if there is any particular asset which is a part of investigation, then in that case SEBI can give an order that you cannot sell off that particular asset till the investigation is complete. Right, and whatever amount is discharged here, okay, whatever amount is discharged means whatever amount is seized, whatever wrongful profits etc. we had made, if that is seized, then that gets transferred. That gets transferred where? That gets transferred to the IEPF. This was the same thing that we had seen in SECRA, right? This was the same thing that we had seen in SECRA. Penalties go to the Consolidated Fund of India, but the discharged amount or the seized amount, that goes to the IEPF, right? Okay, chalo. Now, so this was all about your powers and functions of the SEBI. I'm just very quickly I'm revising again those 5 points. First point was talking about the duty of the board. Second point was talking about some specific powers of the SEBI. Third point was talking about the inspection. Fourth point was talking about the civil court powers, and the fifth point was talking about the actions which can be taken by the SEBI either during investigation or after the investigation has got over. Okay, I hope with this you will be very much comfortable with summarizing the entire provision. Now going to the next section, section number 11A. Section number 11A specifically talks about the prospectus. They say that whenever any particular company comes up with an issue, issuing the prospectus or coming up with a prospectus is mandatory, because that is the offer document, right? That is the offer document that you give to the that you give to the public. So now in that case, because SEBI wants that the prospectus must be crystal clear, because the prospectus must have all the necessary information for the protection of the investors. So it will specify the content. Okay, it will specify the content, what all things should come in the prospectus. First thing is either it can specify by way of regulations. Okay, it will write in the regulations what all things are to be mandatorily given in prospectus by each and every company. Each and every company has to give so XYZ things in its prospectus mandatorily. Okay, and now another thing is if SEBI wants that a particular company or a particular class of companies should disclose some more information, over and above the above one, then in that case it can pass a general or a special order on that particular company, and it can tell that particular company to disclose those extra things. Okay, so by default the rule which is applicable for everyone which will be given in the regulations, and if there is anything which is applicable to a specific company, that will be passed by way of general or a special order, right? Then after that going to the next one is section number 11A, which talks about your collective investment scheme. Collective investment scheme was such a thing where some investors come together, they pool the money, they invest this money, and then they share the returns, right? Now in this case, in case of collective investment scheme, if you want to call yourself as a collective investment scheme, then either you have to fulfill all the conditions of subsection 2, or you have to fulfill the conditions of subsection 2A, and you should not fall in the exceptions. You should not fall in the exceptions which are given in subsection 3. Okay, if you are not falling in 2, if you are not falling in 2A, if you are not falling in 3, then in that case, if you have a corpus of more than or equal to 100 crore, then you will be deemed to be a collective investment scheme, and you will be by default regulated by the SEBI. Okay, earlier, some years back, collective investment scheme was not regulated by the SEBI, but now the collective investment scheme is regulated by the SEBI. Okay, now First of all, if you want to call yourself as a collective investment scheme, by default, you have to fulfill the conditions given in subsection 2. Ma'am, which conditions are we supposed to fulfill as per subsection 2? First of all of you all will come together, all of us will come together and we will contribute money, we will pool the money. Okay, then second point is whatever money we have invested, okay, whatever money we have invested, from that whatever returns we get, these returns will be shared by everyone. These returns, these income will be shared by everyone. Okay, third point, everything, the entire fund is going to be managed on behalf of the investors. For the benefit of investors, it will be managed, and the investors cannot interfere in the day-to-day working because the day-to-day activities will be managed by the management. If all these conditions, if all these 4 conditions are fulfilled, then in that case, we can call ourselves as a collective investment scheme and we will be regulated. We will be regulated by the SEBI. Okay, if those conditions are not fulfilled, but if you fulfill the conditions which are given in the regulations, see, I have circled here. If you have fulfilled all the, I have marked here, not circled. If you have fulfilled all the conditions, as given in the regulations, then also you will be treated as a collective investment scheme. Okay, but now, if there is a cooperative society which comes up with a scheme, same scheme that you contribute the money and we will share the returns with you. If there is a cooperative society, if there is a mutual fund company, if there is a chit fund company, if there is a nidhi company, if there is a deposit taking NBFC, if there is an insurance company, if there is a pension scheme, if there is a provident fund scheme, if there is a public deposit scheme offered by the Companies Act, in all these cases, even though the concept remains the same, that is they pool the money and share the returns with them, then too they will not be treated as a collective investment scheme because they are being regulated by their different laws. Right, so this was all about your collective, investment scheme. You can just read it once, that would be sufficient. Okay, coming to the next one, everyone, power of SEBI to issue directions, same answer as we had done in SECRA. SEBI has got the powers to issue directions to all the persons who are there under section 12 of the SEBI Act. Under section 12 of the SEBI Act means all those who had obtained the registration from the SEBI. It can give directions to the listed company or proposed to the listed company. It can give directions to the RSC, brokers, etc. In which 3 cases can it issue directions? First one is, if it is in the interest of the investors, if it is to prevent the detrimental affairs which is carried on by any of these people, or to secure proper management. Okay, I am repeating, this answer was there in your SECRA also, this is there in SEBI also. To protect the interest of the investors, to secure proper management, and to prevent any affairs which are being carried on in a detrimental manner. If in any of these cases, SEBI has the power to issue directions. Okay, SEBI can issue directions, and those directions will be obviously binding on those all particular persons. And these powers, okay, just try to recollect the note which we had done. These powers will also include one more power, that is, if we have contravened any law and if we have earned any wrongful profit, or if we have averted any losses, then even that can be seized. Okay, even that can be seized, and after seizing, where does it go? After seizing, it goes to the Investor Education and Protection Fund, right? Next one is section number 11C. As I had mentioned earlier, 11C is talking about the investigation. Okay, now suppose if SEBI has the reasons to believe, okay, if SEBI thinks that any activity is not being done in a proper manner, that is, it is being done in a detrimental manner, or if we have contravened any provisions of the law, then SEBI can order investigation in our regards. Okay, it can do investigation of any particular person who is related to the securities market. It can be the company, it can be the brokers, it can be the stock exchange, merchant, any particular person who is related to the stock broker, SEBI can order for investigation. Okay, for this purpose, SEBI is going to appoint a person called as investigating authority, who is going to come and who is going to do the investigation. And now when they come for investigation, what is our responsibility? Our responsibility is to cooperate with them. And to provide them with the necessary information, right? Whatever they are asking, we have to provide them. Whatever they are, demanding from us, we have to give them. Whatever things they have, asked to produce, that we have to produce, etc. We have to cooperate with them and we have to provide them with the necessary information. They can even take our books of accounts. For the purpose for the purpose of investigation, and they can keep it with them for a period of maximum 6 months. Okay, then the investigating authority can also examine us on oath, right? It can tell us to swear, and then it can even examine us on oath if we do not cooperate with them, if we do not provide them the necessary information. If they had told us to sign anything, we did not do it, then in all those cases, a penalty, a punishment will be applicable on us, not to be by-hearted, just to be remembered that if we do not comply with them, then in that case, the punishment will be applicable on them. Then whenever they do any kind of examination, okay, whenever they do any kind of investigation in our company, then whatever questioning they have done, all those things will be written in a particular paper, all those things will be noted down. We have to sign it, okay, the person who was questioned, we have to sign it. After signing it, the investigating authority will read out to us, that person is going to read out to us, and then this can be used as an evidence, right? This can be used as an evidence anywhere, later on in the court of law or later on in any particular proceedings, it can be used, right? Another thing is, suppose during the time of investigation, if the investigating authority, this was a separate point, okay, during the time of investigation, if the investigating authority is of the opinion that we might alter the books of accounts, we may falsify the books of accounts, we may tamper the books of accounts, we may destroy the books of accounts, then in that case, so as to prevent it from this, manipulation, etc., they can seize our books of accounts. But first they'll have to make an application. First, the investigating authority will have to make an application to the court or to the judge, that is to the magistrate or the judge of the designated court. They'll have to go and make an application, and if the judge is satisfied, if the court is satisfied, then it will allow the investigating authority to do this seizure. And in that case, if it is seized, then it can be kept with the investigating authority till the end of the conclusion of the investigation proceedings. Means till the investigation proceedings get over, till that time it can be kept with the investigating authority. And for doing this seizure, we can take the help of that local police or local district administration. We can take help of them, right? Another thing is, one important thing is, the seizure of books of accounts of listed company and proposed to be listed company is not allowed. Seizure of books of accounts, investigation is allowed, but seizure of books of accounts of listed company and proposed to be listed company is not allowed until unless you are of the belief that that company is involved in insider trading or market manipulation, or that fraudulent or unfair trade practice. Another thing coming up here is very simple, that is cease and desist order. Okay, cease and desist order means SEBI can pass a cease or desist order on any particular person who comes under the purview of SEBI. Cease means please stop doing the violation that you are doing now, and desist means not to do that particular mistake again. Right? SEBI can pass this order on any particular person, but when SEBI passes an order on listed company or proposed to be listed company, it can be passed only if it is of the opinion, that that particular company is involved in insider trading or market manipulation, or we can say insider trading or fraudulent and unfair trade practice. Another thing coming up here is section number 12, which is very simple. Section number 12 says that they have listed a few persons, and they have told that if these people want to do the dealing in securities, if these people want to do the trading in securities, then in that case it can be done. It can be done only if they have obtained a registration certificate from the SEBI. Okay, the list is really very long. It can be the stockbrokers, it can be the stock exchange, it can be the merchant bankers, it can be the collective investment scheme, it can be the mutual fund, it can be the venture capital fund, it can be the credit rating agencies, it can be the portfolio managers, it can be the investment advisors, it can be the underwriters, it can be the trustee of the trust deed, that is the debenture trustees, etc. It can be the depositories, it can be the foreign institutional investors, it can be the clearinghouse. There are so many people. We have listed around 14 of them. Okay, all these people are related to whom? All these people are related to the securities market, and if they want to do the trading, in the securities market, then in that case they have to make sure that they have obtained a registration certificate from the SEBI. Right, another section number 12A, not very important, but we can just take out a conclusion out of that. Section number 12A says that they have listed a few things, and they have told that these things, whatever they have listed here, all these things are prohibited. All these things are prohibited. Example, if you are acquiring the control in any particular company in a contravening manner, if you are indulging in insider trading, that is not allowed. If you are indulging in hacking, etc., that is not allowed. If you are trying to defraud any particular person, that is not allowed. If you are making any non-public information as public, that is not allowed. If you are forcing any other person to trade in the shares of a particular company, that is not allowed. So all the wrong things, basically all the wrong things are totally not allowed. That is totally prohibited as per section number 12A. That was the only thing that we had studied. Then going to the next one, finance, accounts and audit. It is very simple. What are they trying to tell us here is SEBI has a fund. Okay, now see, I'm just summarizing all these provisions. SEBI has a fund called as SEBI General Fund. Okay, SEBI has a fund called as SEBI General Fund, which is established by the CG. The money comes from where? The money comes from the central government in form of grants. The money can come in form of fees, charges, etc., which is levied by the CG. Okay, I did not mention penalties. Penalties go to the Consolidated Fund of India. So we are talking about the fees, charges, etc., which is levied by the SEBI. So from these sources we get the inflow. And then these money can be used for what? These money can be used for meeting any admin expenses. This can be used for meeting any investigation expenses, inspection expenses. This can be used for meeting any capital expenditure also as per the capital expenditure plan. This can be used for meeting the objectives of the act. So for all these purposes, the money will be used from the SEBI General Fund only. Okay, then they say that after meeting all these expenses, whatever is the surplus left, that surplus into 25%, that surplus into 25% should be transferred to a separate fund, called as reserve fund. Okay, that money should be 25% should be transferred to a separate fund called as reserve fund. However, the amount in the reserve fund should not exceed the total expenditure of the last 2 years. Means the maximum amount to be maintained in the reserve fund is the amount of expenditure of the last 2 years. Okay, if you already have that much amount in your reserve fund, then no need to transfer anything from the SEBI General Fund in the current year. Then whatever is the surplus left in the SEBI General Fund, that will be directly transferred to the Consolidated Fund of India, and the balance of the SEBI General Fund at the end would be 0. Right? Now, the SEBI has to also maintain its accounts. SEBI has to prepare its accounts as per the format as prescribed by the central government after consulting the CAG. Right? It will be prescribed. In what format are we supposed to maintain it? That will be prescribed by the central government. Its audit will be done by the CAG, and the CAG is going to have the same powers, functions, privileges, etc., which it had while doing the audit of the government companies. Right? Then the CAG will prepare the audit report. It will submit this particular audit report to the CAG will prepare. It will do the audit. It will prepare the annual report. The audit report, it will go to the SEBI. SEBI is going to furnish it to the CG. CG is going to lay it down before both the houses of parliament, just like it happens in case of your government company. Right, after that we have certain penalties coming up. We are going to revise the important penalties. All the important penalties. Okay, first of all, section number 15A. Section number 15A was a similar section which we had studied in SECRA, that if we fail to furnish any information, returns, documents, books, papers, etc. to the SEBI, if SEBI had called and we have failed to submit it, then in that case penalty will be applicable. Minimum rupees 1 lakh, maximum it can go up to 1 lakh per day, but not exceeding rupees 1 crore. Okay, this was one of the important penalty that we had studied there. Another important, very important penalty here was section number 15F. 15F was talking about penalty in case of stockbrokers. 3 penalties only to be written. First one, if the stockbroker has failed to issue the contract note in the specified form, then 1 lakh to 1 crore. 1 lakh to 1 crore is the penalty which will be applicable. Second one, if the stockbroker fails to deliver us the security or fails to pay us the money when it has sold our securities, then the normal penalty will be applicable. Normal means the earlier one. 1 lakh per day, maximum up to rupees 1 crore. And the last one, if the stockbroker has charged brokerage in excess of the limits, in excess of the specified brokerage, then minimum rupees 1 lakh, and it can go up to 5 times the excessive brokerage charge. And out of these two, we have to take whichever is higher. Okay, on this section number 15F, you can expect a direct question. Okay, direct question, state the penalties which will be applicable in case of a stockbroker. Another thing is the penalty in case of penalty for insider trading. Penalty for insider trading, that is given in section number 15G. If any particular person is involved in this insider trading, if any particular person has any price sensitive information, and if he deals on the basis of that price sensitive information, if he communicates this information to someone else, if he forces any other person to deal in this insider trade in the securities on the basis of this insider information, then that particular person would be liable. The penalty applicable there is minimum rupees 10 lakh, which can go up to 25 crore rupees, or 3 times the profit made out of this insider trading, whichever is higher. So minimum is 10 lakh, that is different. In maximum, we have two figures, 25 crore or 3 times the profit made. Out of these two, we'll take whichever is higher, right? So this was another important penalty. 15A we did, 15F we did, 15G we did. 15A was non-furnishing the information to the SEBI. 15F was in case of stockbrokers. 15G is for the insider trading, right? And the next amended one here is 15HAA. 15HAA says that if any particular person is trying to gain wrongful access to the SEBI database, if it's trying to hack the SEBI's database, if it's trying to hack SEBI's website, if it is trying to send a computer virus or initiate a computer virus, etc., where you are trying to destroy the SEBI's data, alter SEBI's data, try to get wrongful access to SEBI's data, then in that case 15HAA is going to get applicable, where the minimum penalty will be of rupees 1 lakh, maximum it can go 10 lakhs or 3 times the profit made out of this, whichever is higher, right? But anyway, 15HAA will be applicable only if it is notified by the ICAI, right? And then we have the residual penalty. If there is any such mistake done by us for which no separate penalty is provided, then the residual penalty will be ranging between rupees 1 lakh to rupees 1 crore. Right, so this was, see, I have written here also the most important penalties: 15A, 15F, 15G and 15HAA. HAA we have simply written because that was a new section which was inserted. Right, now after that going to the next provision, the next provision talks about the power of adjudication. That is, this particular penalty will be determined by whom, or this will be levied by whom? This will be adjudicated by the adjudicating officer, who is appointed by the SEBI only. SEBI appoints a person called as adjudicating officer, who is going to consider, who is going to do the inquiry, who is going to consider the facts, who is going to give the ROBS, and after that, that particular person is going to adjudicate that how much penalty can be levied. Okay, if adjudicating officer levies a penalty which is less, then in that case SEBI can increase that penalty. SEBI does not have the power to reduce the penalty, but SEBI can increase the penalty within a period of 3 months. Okay, then a few points which the AO will consider. At the time of levying the penalty. That is, whenever we have got a range, say for example 1 lakh to 1 crore, then how much to be levied? That depends on certain factors. Okay, that depends on certain factors. Ma'am, which factors? It depends on the repetitive nature of default. It depends on how much loss has been caused to the investors, and it depends on how much gain have we made by doing this wrongful thing. Okay, if we have gained very less and there is hardly any loss caused to the investors, then the AO can decide on a lesser penalty. Right, so 3 factors to be considered. First one, how much loss has been caused to the investors, what is the repetitive nature of default, and how much unfair profits have we derived out of this particular contravention. By considering these factors, we are going to determine how much penalty should be levied. AO is going to determine how much penalty is going to be levied. Okay, and whatever penalty is levied, all those penalties will be collected, and that is credited to the consolidated fund of India. And next thing that we have coming up here is the settlement. In case of settlement, we had studied same concept applicable as that of SECRA. In case of settlement of penalty. Settlement happens in case of penalties, that is the penalties can be reduced. In certain cases, the penalties can be reduced. We should not call it as exactly reducing it, but the original penalty is cancelled and a new lesser figure of penalty is imposed. Right. Then next, moving on to the appeal provisions. For appeal, as we had seen in SECRA also, we have got SAT. We have got an authority called as SAT. SAT is established by whom? SAT is established by the central government. SAT consists of a presiding officer. We had studied this. SAT consists of a presiding officer. It has certain numbers of judicial members. It has certain number of technical members. SAT functions in form of benches. That is in form of groups. And that particular bench is going to have one judicial member and one technical member generally. But in some cases, we can have even more than this also. Now going on to their qualification, presiding officer is such a person who should either be a judge of Supreme Court, or who should be a Chief Justice of High Court, or who should be a judge of High Court for a period of at least 7 years. If any one of the qualification is fulfilled, then that particular person can be appointed as a presiding officer. Then going on to the judicial member, that person should be a judge of High Court for a period of at least 5 years, and that particular person is eligible to be appointed as a judicial member. And for a technical member, that person should be a secretary or additional secretary to the Government of India, to the Ministry of Central Government, or holding a similar post in CG or the SG, or that particular person should be a person of proven ability, integrity, knowledge, standing and having experience in the fields of financial sector for at least a period of 15 years. Okay, if any one of the two conditions are fulfilled, then that particular person is eligible to be appointed as a technical member, right? Now, presiding officer and judicial member. Presiding officer and judicial member are the members who are appointed by the central government after consultation with the Chief Justice of India. And the technical member is also appointed by the central government after taking the recommendation from the search cum selection committee. Okay, the composition of search cum selection committee is not that important. You can simply ignore that. But main thing that you have to remember there is the technical member is appointed by the central government after consulting after taking the recommendation from the search cum selection committee. Okay, if there is any problem, if there is any internal problem in the search cum selection committee, then they say that no problem. The central government wholly and solely has the power to appoint the presiding officer, the judicial member and the technical member. We are not concerned by the internal problems associated in the selection committee. And any particular person who was already a member in SEBI, okay, if there is any particular person who was already a member in the SEBI, cannot become a part of SAT. Okay, because otherwise the decisions will be affected totally. It will be prejudicial. So in that case, suppose if you are a member of SEBI and now you have left your office in SEBI, after that also you have to wait for a period of 2 years, then only you can come and sit in the SAT now. Okay, so basically there is a cooling period of 2 years. Then any particular person who is there in the SAT, who is appointed in the SAT, he is going to have a tenure. He is going to have a tenure of 5 years. And he can be reappointed for one more term of 5 years, but maximum up to 70 years of age. They will be eligible for, obviously they will be eligible for salary, allowances, benefits, etc. So that they have not specifically given here, but they are telling that their salary, allowances, etc. will be as may be prescribed. It will be as may be prescribed, but it should not be varied to their disadvantage. It should not be reduced unnecessarily. Right, now suppose if there is any particular permanent absence, in the place of presiding officer, judicial member, technical member, then in that case that vacancy will be filled. That vacancy will be filled by the central government. There is no problem in that. But if there is, if there is any gap in filling that particular vacancy in the place of presiding officer, then for the meanwhile till the new person comes in the office, then in that case the senior most judicial member is going to act as the presiding officer of the SAT. Okay, senior most judicial member is going to act in the office of the presiding officer. Now, coming on to the 2 points, which talks about your resignation and removal. These people, presiding officer or judicial technical member, even they can resign their office, and whenever they resign, they have to hold their office till a particular period. Okay, they have to still hold their office till a particular period, 3 periods, whichever is earlier. Okay, 3 months notice has to be given. 3 months notice has to be given by them. Then till their successor enters upon their office, or till their term gets over. Out of these 3 dates, whichever is earlier, till this particular date, they have to still be there in their office. Before this, they cannot vacate their office. And then in case of removal, these people can also be removed by the central government, but only after an inquiry has been conducted by the Supreme Court, and the reasons for removal remain the same. Adjudged as an insolvent, unsound mind, financially interested, convicted of any offense involving moral turpitude, abused his position which is not good for the public, etc. So in these cases, the removal can happen only after giving a reasonable opportunity of being heard. Okay, if there are any more changes to be done in this removal, resignation, qualification, etc., then those pointers will be as specified. Those pointers will be specified in the budget that comes in the budget. Those amendments can come by way of budget. Okay, now if there is any internal problem, if there is any particular internal problem, if there is any vacancy in the SAT, that is in the presiding officer, judicial member, if there is any defect in appointment in the members of the SAT, then no problem, the decision can be taken by rest of them. There is no issues in that. Just like we had studied for SEBI, same is applicable for SAT also. In SEBI also, if any particular person's appointment is not proper, etc., then in that case, the other people can take the decision. Similarly, in case of SAT also, if any particular judicial, any particular technical member, any particular presiding officer is not appointed properly, then in that case, the decision can be taken by rest of them. Okay, apart from the members, apart from the presiding officers, apart from the judicial members, apart from the technical members, we can also have some staff. We can also have some employees. Who will be, discharging the functions. So the central government can appoint those employees. Central government can appoint some officers who will discharge their functions, and these people will come under the superintendence, under the control of the presiding officer. Their salary and allowances will be as may be prescribed. Okay, their salary and allowances will be as may be prescribed. Now coming to the main purpose of the SAT, if we are aggrieved by any order passed by SEBI, or if we are aggrieved by any order passed by the adjudicating authority in respect of penalty, then in that case, we can go and file an appeal before the SAT within a period of 45 days from the date of order, and this 45 days period can be condoned. If there is any delay beyond 45 days, then that can be condoned if there is any sufficient cause. And SAT in that case, it will take the decision. It can either confirm, modify, or set aside its own order, and SAT has to try to dispose of this appeal as soon as possible within a period of 6 months. And then once the decision of SAT is final, after that the copy of the order will be sent to each and every person, right? Then SAT has all the powers as vested in a civil court. It is regulated by its own procedure. It can make its own rules. It can make its own regulation. It is not just bound by the civil court's power. And whenever, say for example, there is any dispute in the SAT itself, if the judicial member, technical members, if there is any dispute there itself, then they will refer this matter to the presiding officer. Then the presiding officer himself will get involved, or a new member will get involved, and then we are going to take a revised majority. Right? This is what we had studied in PMLA also. Now, suppose if we do not know how do we represent before the SAT, either you can go if you knew, and if you do not know, then you can send your officers, you can send CA, you can appoint a CA, CS, cost accountant, you can appoint a lawyer, etc., who can represent your case before the SAT. If there is any particular matter where there is no time limit given, then in that case, the time limits given in the Limitation Act would apply. Okay, all these people, the presiding officers, members of the SAT, etc., all these are deemed as public servant. As per the Indian Penal Code. Right? These all are deemed as a public servant as per the Indian Penal Code. And whenever SAT passes any particular order, and if it involves any question of law, then we have to go and file an appeal to the Supreme Court, meaning that civil court cannot interfere in between. We cannot go to the civil court also, and the civil court cannot also interfere in between. Okay, and if it involves a question of law, then you can simply go and file an appeal before the Supreme Court within a period of 60 days, within a period of 60 days, this delay can be condoned by maximum another period of 60 days if there is any sufficient cause. And we are no one to tell to the Supreme Court that, sir, please dispose of the matter within so and so time. That is, there is no time limit specified for the Supreme Court. Right now, central government. Now again, coming back to the CG and the SEBI part, central government has the power. Central government has the power to give directions to the SEBI. Right, it has the power, just like SEBI was giving directions to the RAC. Similarly, CG has the power to give directions to the SEBI, and it will be binding on the SEBI. If SEBI does not comply with those directions, then SEBI invites legal, legal implications against itself after getting a reasonable opportunity of being heard. So basically, SEBI has to comply with all the directions which have been imposed by the central government. If not, then the CG will totally supersede. CG will supersede. It will supersede the management of the SEBI. Means the existing management will have to vacate their offices. Existing people will leave the office. All the properties of the SEBI now comes to the central government. Central government will manage the affairs of the SEBI for a maximum period. This superseding can be done for a maximum period of 6 months, and after a period of 6 months, the CG is going to restore the management. It will appoint new people to manage this particular SEBI. Right? Then after that, just like RAC, just like stock exchange used to submit periodical returns and annual reports to the SEBI, now SEBI will have to submit the periodical returns to the CG. Similarly, SEBI also has to furnish an annual report for the financial year. There it was the calendar year, here it is the financial year. Within 90 days from the year end, it has to submit to the central government an annual report, and once it goes to the central government will lay it where? Central government will lay it before both the houses of parliament. Right? Now, similarly, whenever in all these cases, whenever any particular order is passed by the SEBI, generally, whenever any order was passed by the SEBI or by the AO, if we were aggrieved, then we were going to the SAT. If we were aggrieved by the order of SEBI, we were going to the SAT. Can we go to the civil court? Answer is no, we cannot go to the civil court. Can civil court interfere in between? Answer is no, the civil court cannot also interfere in between. And even all the members of the SEBI, all the officers of the SEBI, all the employees of the SEBI, even they will be deemed to be the public servant as per the Indian Penal Code. Okay, then protection of action taken in good faith was very, very simple. If there is any particular mistake, which is done by the authorities, and if they claim that this mistake was done in good faith, then if they prove this, then in that case, no legal proceedings can be initiated against them. Right? If there is any particular case, next point, if there is any particular case where we have contravened the provisions of the act, then in that case, apart from the penalty, even offences can be made applicable on us, even punishments can be made applicable. Means the wrongful act that we have done, that can be treated as an offence. Right? That can be treated as an offence, and the punishment can be levied. The punishment can be levied by the court, imprisonment or fine or both. Same figures as we had studied that in there in SECRA. Okay, offence can be made applicable, and that offence can even be compounded. Okay, that offence can be even compounded. Just to recollect one more thing, which offences cannot be compounded? The offences which contains mandatory imprisonment. The offences which contain mandatory imprisonment, those cannot be compounded. Then coming on to the next one, that is immunity. Same thing that we had done in SECRA. Immunity can be granted. Immunity can be granted by the central government on recommendation from the SEBI. Immunity can be granted from both. It can be granted from the penalties also. It can be granted from the offences also. But whenever the matter goes to the court will take up our case only if someone has gone and submitted a complaint. Someone has gone and given the note of that particular offence. That someone can be central government, it can be state government, it can be the stock exchange, it can be any particular person associated with these particular authorities. They have to go and give the cognizance of the offence. Then only the court will interfere. Then only it will consider our offences. Right? Now here the court which is going to consider all these things is the special court. So just like we did in SECRA, just like we did in PMLA, special court is nothing but the court of session, right? The session courts are designated as the special courts. It can designate as many number of special court as it wants for a particular area. If in a particular area we have more than one special court, then to which special court the case will go, that will be decided by the High Court. Any proceeding which is going on before the special court, that will be deemed to be a judicial proceeding, and the Code of Criminal Procedure is going to apply to such proceedings. Right, just like initially High Court used to regulate the Session Court, similarly High Court is now going to regulate the Special Court also. Right, and any person who conducts the proceedings before the Special Court, that person is treated as a public prosecutor. That person is deemed to be a public prosecutor, having how many years knowledge? Having 7 years knowledge in the field of law. And till the time the special courts are appointed, the case will be handled by the Session Court, and if there is no Session Court, then it will be handled by the magistrate. Right. Next one, if there is any offences done by the company, then the person in charge would be liable, but in 2 cases he won't be liable where he proves that this offence was done without his knowledge, or he had exercised or he had expressed due diligence to prevent such kind of offence. Right. Next one is recovery of amount. Whenever any penalty etc. is levied on us, and if we are not paying it on our own, then in that case there will be a person called as recovery officer who will be appointed, who will recover the penalties from us by 5 ways. Okay, it can attach our bank accounts, it can attach and sell off our movable property, immovable property. Then after that it can arrest us, it can put us in the prison, it can detain us, and the last one is it can appoint any particular person as receiver to manage the properties. These are the ways which we had studied in your SECRA chapter also. Next one is the central government. Central government has the powers to make the rules, as we have studied. Again, I am repeating same thing that we had studied in SECRA. Here CG has the power to make the rules, and once it makes the rules, it has to make sure that it is laid down before both the houses of parliament for 30 days period. Right. Similarly, power to make regulations. SEBI has got the power to make the regulations, but it should not be against. It should not be against the CG's order. It should not be against the CG's order. And later on, even this will be laid before both the houses of parliament for a period of 30 days. And along with SEBI, other laws can also be clubbed. There is no such restriction that along with SEBI, no other law can be made applicable. So SEBI can individually be also be applied, and SEBI can applied in conjunction with any other law also. And section number 34, I had told you, as of now this is not at all relevant because the time period has totally gone. And these are the appeal time periods which we have already revised. So this was all about our SEBI Act revision. I hope you all have recollected the provisions. You all are comfortable with the revisions. Do let me know. Okay, so let's start with the revision of the SEBI LODR Regulations 2015 as amended by the Amendment Regulations 2018. Let's start with them. First of all, the full form of LODR. The full form of LODR is Listing Obligations and Disclosure Requirement. There were two main objectives. Of the LODR. Regulations. First one is to align the clauses of listing agreement, that is specifically clause number 49 of the listing agreement with the Companies Act. That was the first objective, right? That was the first objective of the LODR regulations. And the second one is we had different listing agreement conditions for different securities. We had different conditions for different types of securities. So now we are going to consolidate all of them into a single regulation. That was another objective of your LODR. LODR is applicable to each and every listed entity. It is applicable to each and every listed entity whenever they are issuing any such securities which are going to be listed on the recognized stock exchange. Right? It is applicable to equity shares, it is applicable to preference shares, it is applicable to any other debt securities, it is applicable to mutual funds, any such securities which are going to be listed on the recognized stock exchange. Right? Now, apart from that, now going on to the main regulations. First one is regulation number 6. Regulation number 6 talks about the compliance officer. Regulation number 6 talks about the compliance officer, and they say that every listed entity should have at least one compliance officer who should be a qualified CS, and he has 4 obligations. He will be responsible for 4 things. Okay, what are the 4 things for which he is responsible? First of all, he has to make sure that all the compliances have been followed. That is regular compliance. Meeting all the regular compliance is the obligation of the compliance officer. Second one is coordination and reporting to the board. Third point, ensure that correct procedures have been followed so that whatever information we are submitting to the authorities, that information is correct and that is as per the regulations. And the last one, fourth point, is to monitor the email address of the grievance redressal division. Right? These were the 4 obligations. Of the compliance officer. Okay, after that we have regulation number 7. Regulation number 7 talks about the share transfer agent. Every company should have a facility. For share transfer, right? For doing the share transfer thing, it should have this facility. That can be either in-house or that can be outsourced to any other person. We had taken in regular lectures, we had taken the example of Karvi computerized services there. Another one coming up here is regulation number 24. Regulation number 24 talks about the corporate governance in respect of unlisted material subsidiary. Right? It talks about the corporate governance in respect of unlisted material subsidiary. Why are we not talking about the listed ones? Because anyway, to the listed subsidiary, to the listed holding company, etc., the LODR would be applicable. So now here they are telling about 3 points. Okay, here they are telling about the 3 points. First one is any person who is an independent director. Okay, 3 points. Everyone just try to recollect. The first point was any person who is an independent director on the board of the main company, that is a listed holding company, should also be a director on the board. That one person, same common person, should also be a director on the board of this unlisted material subsidiary. Okay, and this unlisted material subsidiary can be a foreign company, it can be an Indian company, and it is such a company which contributes more than 20% of the total income, consolidated income, or more than 20% of the net worth. Means it is having its income is more than 20% of the consolidated income of the entire group, or its net worth is more than 20% of the consolidated net worth of the group. So first point was talking about having a common director. Second point which is coming up there is, second and third point were similar. Second point was, if a listed company wants to dispose of the shares in the unlisted material subsidiary, and because of this disposal the shareholding is going to fall below 50%, then they are telling that if you want to do this, you can do this only after passing a special resolution. Right? You have to pass a special resolution in the general meeting, then only you can dispose of the shares which can go below 50%. And in other cases, suppose if you don't want to, there are 2 such cases where passing of SR is not mandatory. First point was, whenever we have received any particular order from any court or tribunal, or whenever it was approved as per the IBC resolution plan and intimated to the RSC within a period of 1 day. In these 2 cases, you are not required to pass any SR because these orders override the special resolution. And the third one was, if any unlisted material subsidiary wants to sell off, if it is selling off, disposing of, leasing off its asset of more than 20%, right? More than 20% of the assets of the unlisted material subsidiary is getting sold off, is getting disposed of, is getting leased, etc. Then in that case, again you have to pass a special resolution. The listed holding company will have to pass a special resolution in the general meeting, but SR in general meeting is not required again in those 2 cases. First one is, if the court or tribunal has passed any order, or if it was approved because of the resolution plan under IBC, and in such case it was intimated to the recognized stock exchange within a period of 1 day. Right? This is what we had studied in regulation number 24. Then after that, going to the next one, we had studied some points about the quarterly compliances. We had studied 5 points about the quarterly compliances. In that, the first one is the grievance redressal mechanism. That is, for every quarter, how many complaints did we have at the opening, how many new complaints we received, how many were solved, how many were finally left. This reporting we are supposed to do to the recognized stock exchange within 21 days from the end of the quarter. Right. Second one is other corporate governance requirements. If RAC says that you have to do some other reporting also, then we'll have to do that other reporting to the recognized stock exchange within 15 days, from the end of the quarter. Third thing was we had to submit the report about the shareholding pattern 3 times. 3 times we had to submit the data about the shareholding pattern. First one is 1 day prior to listing. Okay, 1 day prior to listing. This can be a proposed to be listed company also. Only for this point, it can be a proposed to be listed company also. That 1 day prior to the listing, it has to submit to the recognized stock exchange its shareholding pattern. Then on a regular basis, it has to do on quarterly basis within a period of 21 days from the quarter end. And then whenever there is a capital restructuring happening in the company, and whenever there is a change of more than 2% in the paid up share capital, then we have to report it within a period of 10 days. We have to give the details about the shareholding pattern within a period of 10 days. Next thing was about the financial results. Financial results, we had combined this point with some other point also. In case of financial results, for the first 3 quarters, we are going to submit it within 45 days from the quarter end, and for the last quarter, we are going to give it along with the yearly results, that is within 60 days from the year end. And the last one was about the statement of deviation or variation. Statement of deviation or variation. Deviation means whenever there was a change in the main objective, right? The main objective of our company for which we had, taken the public's money, if that has changed altogether, then you have to report it to the recognized stock exchange on quarterly basis. And whenever there is an internal bifurcation change, the main objective, the main business hasn't changed, but the internal bifurcation, that the, allocation between the capital expenditure, allocation between the revenue expenditure, etc. If that has changed, then in that case also we are supposed to report this to the recognized stock exchange on quarterly basis. Right? Then after that, the next point which was coming is talking about the prior intimation, that whenever we are holding any board meeting for some important matters, at that time we have to report it to the recognized stock exchange. Total we are going to study 6 points here. Out of that, 4 points are those points where we have to intimate it to the recognized stock exchange, and 2 points are talking about the compliance. Okay, now in that 4 points, the first one is whenever we are going to conduct a board meeting for adopting the financial results, then in that case we have to intimate. Before the meeting, we have to intimate at least 5 days in advance. To the recognized stock exchange that we are going to conduct a particular board meeting for that. Second one was when we are conducting any board meeting for some other matters, like it can be buyback, it can be delisting, etc. Then in that case, we have to intimate at least 2 days before that particular board meeting. Okay, then 11 days, so long days, 11 days came into picture whenever there was any change in the interest dates, or whenever there was change in the rights and privileges of the security holders. Then in that case, we have to intimate to them at least 11 days before this particular meeting. And another thing was whenever we are going to, whichever date we are going to set as the record date, that is a book entry date, whichever date we are going to set as a record date, at least 7 days before, we have to intimate to the RAC that, sir, so and so date we are going to fix as the record date. So these 4 points were such things where we had to intimate about the days. These 4 were such things where we had to intimate about such days to the, to whom? We had to intimate it to the recognized stock exchange. And then the 2 points, more 2 points coming up there. That is, first one, there should be a gap of at least 5 days between the actual date of declaration and between the record date, right? There should be a gap of at least 5 days there. And then whenever there is any change in the content, then in that case, that change must be updated on the company's website also within a period of 2 days. Right, so the last 2 points that we studied, that there should be a gap of 5 days between the date of declaration and record date, and secondly, the changes on the website should be reflected within a period of 2 days. These 2 points were talking about the compliances, and the earlier 4 points were talking about the intimation that we had to do to the recognized stock exchange. Another thing coming up here is just 2 to 3 points coming up in the annual and the yearly compliances. They are telling that in annual or yearly compliances, we are supposed to submit the annual accounts or the annual statements or the annual financial statements to the recognized stock exchange within a period of 60 days from the year end, as we just discussed. It will be along with the audit report, which can be either in form A or it can be in form B, depending upon the type of opinion. Then they are telling that annual report copy, the booklet copy which we had discussed, the entire booklet which contains the annual report of the company, that should be sent to the recognized stock exchange. See, that is sent to the shareholders also at least 21 clear days before the general meeting. So they are telling that as soon as you start dispatching to the shareholders, immediately you have to start dispatching to the dispatch it to the recognized stock exchange also. And if at all in the annual general meeting, if there is any changes in this particular annual report, then within 48 hours from the AGM, within 48 hours of the AGM, you have to again submit the revised copy. You have to again submit the revised copy to the recognized stock exchange, right? So that was all about your annual compliances. That's it, right? And after that we spoke something about the corporate governance. In corporate governance, what were they telling that specifically for related party transactions, earlier the resolution required was special resolution, but now everything is at par, and now ordinary resolution is only required for approving the related party transactions. So now basically section number 188 of the Companies Act is at par with the LODR regulations, or we can say it is at par with the clause 49. It is at par with the clause 49 of the listing agreement. Now, in that they are telling that suppose if there was any such related party transaction which was approved earlier before this particular amendment, so just for ratifying it, please place it before the general meeting so that the shareholders can pass an ordinary resolution and they can ratify it. So basically they are making sure that we have complied with all the new provisions. After that we had studied 4 committees. In this. In that, the first committee is the important committee, that is the audit committee. First of all, they are telling that every listed company must have an audit committee for sure, and every audit committee must have at least 3 members, means 3 directors. It should have at least 3 directors in that, and out of that, at least 2/3 of the directors must be independent directors. Right? All the members of the audit committee, they should be financially literate, right? All of them should be financially literate, and at least one of them should have proper expertise. At least one of them should have proper expertise in that. And the chairperson of this particular audit committee, that person has to be an independent director, because we have to exercise high level of independence in this particular audit committee, and he will be present before the AGM. To answer all the queries which are raised by the shareholders. The company secretary will be acting as a secretary of this audit committee also, that is calling for the meetings, issuing the notices, etc. That will be the work of that particular secretary. Then when we talk about the meeting, then in that case audit committee is going to should hold at least 4 meetings in a year. This is just like your board meeting. So audit committee also should conduct at least 4 meetings in a year, and the gap between 2 meetings should not be more than 120 days. Right, now coming on to the quorum, what should be the quorum? So in quorum there should be at least 2 members. Or 1/3 of the total members of the audit committee, whichever is higher. Okay, so 2 members or 1/3 of the members, whichever is higher, but with at least 2 independent directors present there. Okay, with at least 2 independent directors present there. This is what we had studied for the audit committee. Powers of the audit committee, we are going to take it from section number 177, and that's why I have ignored here. Another committee that you have to set up is the nomination and the remuneration committee. This committee was formed mainly for nominating the directors, for recommending the directors, for deciding upon their remuneration, to see their status or to see their performance, etc. This committee was basically set up. The main purpose of the NRC, this is what we have discussed. Now going on to the composition. In this NRC also, it should have at least 3 directors. But one thing is very, very important here. Whoever is present here in the NRC, all of them should be the non-executive directors, and in that at least half of them, just like we studied for the earlier, at least 2/3 should be independent. Here at least half of them should be independent directors. Even the chairperson would be an independent director. It should make sure that it has met at least once in a year. Okay, the frequency of the meeting here is at least one meeting in a year. And talking about the quorum, it is almost same as that of your audit committee. So 2 directors or 1/3 of the total members or directors, whatever you want to call, 2 members or 1/3 of the members of the committee, whichever is higher, but with at least one independent director present there. There it was 2 independent directors present. Here it is 1 independent director present. And one important thing here is the person who is the chairperson of the company. The person who is the chairperson of the company cannot be a chairperson here. However, he can be a member of this nomination and remuneration committee. Going on to the next one, that is the Stakeholders Relationship Committee. Going on to the next one, Stakeholders Relationship Committee. This is such a committee which has been set up to address various aspects of the security holders, that is your equity shareholders, preference shareholders, debenture holders, or any other security holders, or the grievances, all the questions which are raised by the security holders will be answered, or that has to be handled basically by this Stakeholders Relationship Committee. Now, here they are telling that how many members should be there. First of all, 3 members, at least 3 members should be there in this particular committee, with at least one independent director present in that particular committee. Then after that, this committee also has to meet at least once a year. Here the quorum has not been specified. And the most important thing here is again the chairperson of this particular committee. Even that person has to be a non-executive director, and he will be present before the AGM. Just like your audit committee, even this particular chairperson will be present before the annual general meeting so as to answer the queries of the shareholder. Another important committee which is coming up here is your Risk Management Committee. Top 500 listed entities as per the last year's market capitalization is compulsorily required to establish this committee called as Risk Management Committee. Till now, whichever committees we were seeing, those committees were to be established by every listed entity. This is such a committee which has to be established by the top 500 listed entities as per the last year's market capitalization. They have to establish this Risk Management Committee. The main purpose of this particular committee is to monitor the risk, to review the risk, to make sure that we prepare a risk plan, including a plan which talks about the cyber security. Right? Then after that, in this Risk Management Committee, they haven't specified how many members should be there, but they have told that senior executive of the board would be the members in this particular committee, depending upon the knowledge and the experience. And the frequency of meeting is at least one meeting in a year. Again, here the quorum has not been specified. Right? The important pointers from all these committees I have written in the summary chart, so you can refer it from there. Then after that, your ICI has put up some key features of the LODR regulations. In that specifically, point number 1 and point number 3 is specifically important. In that, point number one, first of all, it talks about the composition of the executive directors and composition of the non-executive directors. First of all, the most important thing to be fulfilled there is the composition of the non-executive directors in the company. In the company, there should be more than or equal to 50%. More than or equal to 50% of the directors should be non-executive directors. Okay, there should be non-executive directors. More than half of them, more than or equal to half or more than half should be non-executive directors. Now, in that also, there should be a particular proportion of independent directors. Okay, now if the chairperson of the company is a non-executive director and he is unrelated, he is totally unrelated to the other members, to the affairs of the company, etc. Then in that case, if the total board, even if 1/3 of the total board is independent director, then that is allowed, no problem in that. If we have a non-executive chairperson but he is related, then in that case, at least half of the board should be independent director, so as to just ensure integrity and independence. And suppose if you do not have any non-executive chairperson, means the chairperson is an executive person, then in that case, again half of the board should be an independent director. Then they were talking about the board meeting. Just like your audit committee frequency, the board should meet at least 4 times in a year, and the gap between 2 meetings should not be more than 120 days. Then they were talking about the restriction that a particular person can be a committee member in how many committees, he can be a chairperson of how many committees. First of all, when we talk about the membership, okay, if Arpita is a member of committees, Arpita is a member of committees, then Arpita can be a member of maximum 10 committees. Okay, Arpita can be a member of maximum 10 committees, and in this committees we are just going to take two committees. One is audit committee and the SRC, that is stakeholders relationship committee. Okay, now ma'am, what about the other committees? So if Arpita is a member of any other committee, then that won't be considered in this particular ceiling, meaning that there is no limit on the membership in other committees, right? And then if Arpita wants to become a chairperson, in any particular committee, okay, if Arpita wants to become a chairperson in any particular committee, then in that case I can be a chairperson in maximum 5 committees. In whatever companies I am involved, totaling in all the companies, maximum 5 committees I can be a chairperson. Okay, here while calculating the companies, the total company, we have to take all the types of company except for 3 companies. One is private companies to be excluded, foreign companies to be excluded, and section 8 company. Okay, that exclusion is applicable for both of these, basically it is applicable for the entire point. So suppose now if I am a chairperson, I am a member of any particular committee in private company, in foreign company, in section 8 company, then that is not to be counted at all, means there is no restriction on that particular number. Then after that, 4th and 5th point we have already studied before, audit committee and the corporate governance part. Then 6th point says that, the company is required to make certain disclosures. As given in regulation number 30, which talks about some related party transactions, which talks about IPO, which talks about your risk management, which talks about the accounting treatment, etc. Some required matters which are already stated in regulation number 30. You have to give the proper disclosures of that. Then the CEO, LODR says that CEO and CFO of the company should mandatorily certify and review the financial statements and the cash flow, of the company. That is mandatory. This is what they are trying to say. And the last thing which is coming up here is LODR also requires that certain reporting. See, till now maximum things that we were studying was whatever things we had studied, all those things had to be reported to the recognized stock exchange. All those things had to be reported to the recognized stock exchange. Now they are telling that there are certain more things which are to be reported to the members of the company, and we report it to the members of the company by way of annual reporting. The annual report that we submit to the members, it contains all these information, right? And this is nothing but your summary. This is nothing but your summary of different types of committees from which I had told you that you can just revise it from here. Right, so only this much was your LODR. I hope you are clear with this.